Hi, I'm Chip Richardson, an attorney in Washington, D.C. Welcome to my video series, Get Your Legal House in Order. Today's video topic is 5 core documents that form the basis of any estate plan. I chose today's topic to take some of the fear and mystery out of basic estate planning, and also to encourage more people, young and old, to put estate plans in place, or at the very least, have your will done. The first document I want to discuss is the will. The will is a legal instrument which provides a set of instructions on how things are to be handled after a person has passed away. The will legally disposes of a person's assets after death. It also identifies a person, known either as an executor or a personal representative, whose task it is to handle the person's affairs after they have passed. What the will does not do is avoid probate. However, if drafted properly, it will avoid intestate distribution. Now that sounds complicated, but what it really means is that the law, by statute, will decide how property is passed if a valid will is not in place. The second document is known as a trust. The trust is also a legal instrument. It also provides a set of instructions on how assets are to be handled and managed, both before a person passes away and after. A person is identified within the body of the trust, whose task it is to manage the instructions set forth in the trust, and that person is known as a trustee. A well-drafted trust can work in tandem with a will and avoid a lot of the headache and administrative complexities of the probate process. The next document I want to discuss is a general durable power of attorney. It is general in that it is broadly drafted and broadly intended to confer on another person the authority to do many things that could otherwise be done by the person who drafted the document. It's known as a durable document in that it continues to operate even after a person becomes incapacitated or unable to communicate decisions or unable to make decisions on their behalf. So a general durable power of attorney is a legal instrument that is intended to confer on another person the authority to do those things that are set forth in that document. It can be broadly drafted to confer many obligations and powers and duties on a person, or it can be more narrowly tailored to restrict the authority in the document. The next type of power of attorney in the next document is called a healthcare power of attorney. Now, healthcare power of attorney is also a power of attorney which is narrowly tailored or strictly drafted to deal only with specific healthcare decisions. Oftentimes, general powers of attorney are insufficient to confer proper authority on another person to make healthcare decisions. Medical professionals and medical facilities often rely on healthcare power of attorneys to ascertain whether or not proper authority has been given to another person to make specific healthcare decisions. Now, like the general durable power of attorney, the healthcare power of attorney can be drafted broadly with respect to healthcare decisions, or it can be more narrowly tailored with respect to healthcare decisions based on your particular needs and the wishes of the drafter. The last document is known as a living will or an advanced medical directive. And that's a legal instrument that puts in writing your desire to either have life-sustaining measures administered or life-sustaining measures withheld in the event that you are unable to live without artificial life-sustaining measures being applied. Now, this document is a very important document, and it must be in writing. And that document is relied on by medical professionals and medical facilities in determining a person's wishes should that situation arise. Equally as important, it serves to act as a guide for caregivers and loved ones who may be placed in the unfortunate position of having to make decisions regarding end-of-life decisions. So just to recap, we discussed briefly the will, the trust, the general durable power of attorney, the health care power of attorney, and the living will. These 5 documents can form the basis of any basic estate plan. Now, your individual needs may vary, and your plan may consist of all or some of these, or your estate plan may require additional documents. My suggestion is that you take the time, do your research, consult with an attorney, and the best of luck to you. Thank you.